It's going to take a bit anyway. Good evening. This is the House Judiciary Committee. It is March the 18th, 2021. This is our voting session. It's about 9:30 on the 18th of March. I'm going to start this evening. House Bill 89 came out. Who is not muted? Can we mute Delegate? There we go. Until he wants to talk. House Bill 89. This is Delegate Wilkins' bill that went to the Public Safety Committee. And they made several amendments. Madam Vice Chair, are you here? There you are.
Yes.
Can you talk about the amendments that were done to House Bill 89, please?
Yes, thank you, Mr. Chair. So House Bill 89 was amended and voted favorably out of the Public Safety Committee, 7-2. Some of the amendments match what JPR did with the bill last night when they voted. So I'll just go through the amendments beginning on page 2. And if you go to line 13 and 14, it was amended to state that an inmate cannot earn more than one associate degree and not more than one bachelor's degree. And that is in response to individuals concerned about being able to quote unquote stack degrees to earn credits. Then if you go to line 15, we matched what the Senate did in terms of days you could earn per completed program. So they said 60, we matched the 60. The bill came in at 90. And then in section B2, when the bill deals with crimes of violence, the Senate said 40 days per program completed for someone who was serving a crime of violence. And we agreed with that and matched what they did. We also amended the bill in section B3 to say that an individual who is serving a sentence for a sexual offense could not receive credits for participating in any of these programs. And that matches also what the Senate did. And so the only thing in our bill that does not match what the Senate did is in lines 13 and 14, where we say essentially you can't stack multiple associate degrees or multiple bachelor's degrees to earn credits. And that's the bill.
All right. First things first, there are a set of amendments to the bill. Is there a motion on the amendments?
Move the amendments.
Move the amendments and seconded. All right, we're on the amendments. Is there discussion on the amendments? Seeing no discussion on the amendments.
I think Delegate McComas is waving.
Delegate McComas on the amendments. Can we unmute Delegate McComas?
The sexual offender cannot get any diminution credits.
Would you
They
repeat?
still participate in the.
Delegate McComas, your
basically-
question broke up. Okay, try again.
Okay, all right. The sexual offender cannot receive any diminution credits under this bill, but I wanted to know if they can still participate in the education that's offered. In other words, could they go ahead and still pursue, and they could do that now? They just
Sure.
wouldn't get any credit for it.
Correct.
Okay, all right. Thank you.
Yeah. Any further comments on the amendments? Seeing none, all in favor of the amendments, please raise your hands. Delegates Shetty, Bartlett, Watson, Williams, Atterbury, Griffith, Davis, Cham, Lopez, Grammar, Cardin, Conaway, Crutchfield, Moon, Cox. Anyone opposed to the amendments? I see Rachel Jones as well. Anyone opposed to the amendments? Seeing none, the amendments are adopted. We're now on the bill as amended. Is there a motion on the bill as amended?
Move the bill as amended, Mr. Chair.
Motion for
Second.
favorable on the bill as amended and a second. Discussion on the bill as amended, and I thought I saw Delegate Rachel Jones, but I don't anymore. Not anymore, okay. Is there any further discussion on the bill as amended? Seeing none, we'll take a roll call. The Vice Chair,
Yes.
Delegate Arakan,
No.
Delegate Bartlett,
Yes.
Delegate Cardin,
Yes.
Delegate Conaway,
Yes.
Delegate Cox,
No.
Delegate Crutchfield,
Yes.
Delegate Davis,
Yes.
Delegate Juanita Fisher. All right, Delegate Grammar,
No.
Delegate Griffith,
Yes.
Delegate Jones,
Yes.
Delegate Leslie Lopez.
Yes.
Got the names all screwed around now. Delegate Malone,
No.
Delegate McComas,
No.
Delegate Moon,
Yes.
Delegate Shetty,
Yes.
Delegate Cham,
Yes.
Delegate Watson,
Yes.
Delegate Williams,
Yes.
Delegate Juanita Fisher. 89, dim credits.
Yes.
All right. 6 against 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 15. How is that possible? 1, 2, 3, 4, 5, 6. Oh, that's how that's possible. 15-5, motion carries. Okay. Our secondary on House Bill 222, Delegate Wilkins' bill, the Value My Vote Act. It addresses issues related to voting by people who are still qualified to vote. So these are people who are not incarcerated for a felony. So they can be incarcerated for anything else, but they can't be incarcerated for a felony. So they're still eligible to vote. There are amendments on the bill, and Delegate, so these have bounced here from Ways and Means, and we're making a couple amendments. Actually, the Ways and Means Committee has voted this once, so they're going to vote it again. I'll talk about the changes that we made. If we could go down, please. Let's see. All right, the changes that we made, and actually, Holly, could I ask you to talk about the changes that were made here after a conversation with the Department of Public Safety and Correctional Services? They indicated that they already do some of these things, but they had some concerns that we've addressed, and we've spoken to the sponsor, and I think we've got to the right place. So-
Sure. So in the first section 2502, if you look at number 4, what we did there is we took out the training component, and now all we provide is that the facility should designate an employee who will serve as the primary point of contact for the implementation of this subsection, and we don't require that employee to have a training component. That is the First Amendment. The Second Amendment, if you go down to page 3, subsection D, paragraph 3, the state board shall engage nonpartisan community organizations. The language there included the department. We have removed the department from that language, so just the state board shall engage. And then the final amendment is on page 4 and 5. And all we did is in subsection D, subsection E, and at the end of the bill in section 1303, anywhere it referenced the department, we also added correctional facilities to make sure the local correctional facilities were also included. Under the department, it would just be the state facilities, and we wanted to make sure everybody was under the bill.
And while that would be, as we're aware, the Baltimore City, their detention center is covered by the Department of Public Services, is operated by DPSCS. The majority of people who are held on misdemeanor counts and counts for where they'd still have a right to vote are held in local detention centers. I don't think they're held at the Department of Public Service or the Department of Corrections. So could I have a motion on the amendments, please?
Favorable.
There's a motion for favorable on the amendments. Is there a second?
Second.
Second.
That's fine. All of, could we go back to the big screen? All in favor of the amendments, please raise your hand. Delegates Shetty, Bartlett, Washington, Williams, the vice chair, Deborah Davis, Lopez, Cardin, Conaway, Crutchfield, David Moon, Fisher. That's 12. All those opposed? Opposed to the amendments. Delegates Cham, Griffith, Grammar, Malone, Cox, McComas. I think I got it. I think I got everybody. So the amendment is adopted. So we're now on the bill as a
Favorable.
motion for a favorable. Is there a second? There's favorable in a second. Is there further discussion on the bill as amended? It's a favorable as amended. Seeing none. Wait, are you raising? Yes. Delegate McComas. Got to be unmuted.
Just a real quick question. Did our local folks that have the detention centers, the counties, did they weigh in? Because now we've kind of moved it over to them more than public safety. And it is a mandate on local government.
Well, I know that I've spoken to the Department of Public Safety. I think that they heard this bill primarily in Ways and Means, and their intent there was to include the locals as well. I didn't get any indication that they were opposed. I did not myself, however, call them. I'm just being.
Well, they honestly might not have known either. I mean,
I understand that.
yeah. Okay,
And-
that's just
But a lot of these things, for what it's worth, the responsibility of it actually narrows down what the jails themselves are supposed to do, in the sense that it narrows down. They basically have to put up signs, and they provide for a drop box within the facilities, and a lot of these facilities are already doing that. This is something that they already are doing. They already are putting up signs. They designate a person to be a point of contact in the bill. And then outside of that, the State Board of Elections would pick an ombudsman to work with local detention centers. So really, this has taken the burden off of the local of the detention centers at this point, and just required better communication between the Board of Elections and the correctional facilities. All right. Is there any further discussion on the bill? All right, seeing none. Delegate Cham?
Yes, sir. Thank you. Thank you, Mr. Chair. Just for clarity, this bill these individuals already have a right to vote, is what you're saying? And once
Yes.
they're discharged, they're giving voter registration information to
Yes.
register and vote.
Yeah, someone who is convicted of a misdemeanor still has the right to vote. If you were convicted of a felony, you can't vote while you're incarcerated. However, after your time of probation is completed, then you can re-register and vote again.
Okay, thank you.
Right. Delegate Griffith.
I'm sorry, Mr. Chair, I know it's late. Clarification, so give them the registration and then collected and sent it in form, or are they just handed the information as they're released?
They're given the information, and then they would have to turn it in. Obviously, after they're released, they would have to turn it in. They'd have to mail it into the Board of Elections. But it also, they would also be able to, that point of contact would also be able to receive materials like absentee ballot application that they would have to mail in to the Board of Elections in that particular, or wherever they are registered to vote. They would not be registered to vote in the facility. They were registered wherever their last address was.
Thank you, Mr. Chair.
Thank you. Any further questions or comments? All right, seeing none, we'll roll call. The vice chair,
Yes.
Erican,
No.
Bartlett,
Yes.
Carden,
Yes.
Conaway,
Yes.
Cox,
No.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanita Fisher,
Yes.
Robin Grammer,
No.
Griffith,
No.
Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
No.
McComas,
No.
Moon,
Yes.
Shetty,
Yes.
Cham,
No.
Watson,
Yes.
Williams.
Yes.
13-7 is what you have. Okay, 13-7. Favorable motion passes. It will go back to Ways and Means. All right, we'll go now to House Bill 315. 315. Delegates Bartlett's bill. And she is on the call. She has worked really the length of the session with advocates on the legislation. There are amendments that she has. Delegate Bartlett, why don't you tell the committee what the amendments do, what the bill does as amended?
Sure, I will as best as I can, and if I could lean on counsel, if counsel is available.
Yes.
So as the bill is amended, it will require, well, it actually, we made one amendment to the court to ask, to state that the Court of Appeals may adopt rules concerning age-appropriate language. And we did that because we want to make sure that we have no question of constitutionality between separation of powers. So we made those amendments as needed in the on page 1. We also indicated that a police officer should, make an effort to provide notice to the child's parents. And we have outlined how that's going to be. But on the first page, it's just, some technical amendment, no, not technical, but some amendments based on the meat that's coming. So for instance, one on line 21, we added new information that states that the interrogation, when we have exigent circumstances. So essentially what the bill does is when the police officer is able, the police officer who takes a child into custody should make a reasonable effort to notify the parent or guardian. Also, the child has a right to counsel. And so the child will have the consultation of counsel. If it is OPD, then the Office of the Public Defender's Office will be notified, and whoever is on as counsel for Office of the Public Defender will handle the case. If they have private counsel, of course, then they just have private counsel. But the child must have counsel, and they must have that opportunity to have counsel. If for some reason there are exigent circumstances where there's a threat of life or that is endangered, then what we have on page 1 is this language. If you could just make it just a little bit bigger deal, and that would be great. But anyway, requiring that an interrogation of a child be recorded where there are jurisdictions that have body-worn cameras. And this is for the exigent circumstances because otherwise there's just no record of anything. And so it helps law enforcement as well as the child who we are trying to protect. And so let's move on because that page just explains everything.
Let's go past the purpose paragraph.
Yeah, the purpose paragraph, exactly. So page 2 at the bottom, we have added, this is the information about that the law enforcement, if they take a child into custody, then they should immediately notify or cause to be notified the child's parent, guardian, or custodian, and that's the language about in a manner reasonably calculated to give actual notice to of the action. On page 3, we state what the notice shall include. It should include the child's location. Parents need to know where their children are. Provide the reason for the child being taken into custody, and instruct the parent, guardian, or custodian on how to make an in-person contact with the child. Number 2, providing the reason for the child being taken into custody goes in line with the bills that we have passed, in which law enforcement, must give you a reason if they stop you. So that's not out of line with anything there. Okay, same page at number 2, we also state in section on number 2, we state that after making that effort to give actual notice to a child's parent, guardian, or custodian, then the law officer shall, with all reasonable speed, then we get into release the child to the parent or custody or anyone else who's designated by the court upon written notice to bring the child back. That was already in the bill. And so I'm going to go down to 2.1 So 2C, if a parent, guardian, or custodian fails to bring the child back to the court when requested, the court may issue a writ of attachment directing the child to be taken into custody and go ahead and proceed against the parent or custodian for contempt. Then at section E, this is where we get into the Court of Appeals may adopt rules concerning age-appropriate language. Now on page 4, we have deleted, the Court of Appeals asked us not to specifically tell them what to say. So we've deleted that section. But we wanted to make it clear that what the intention of the age-appropriate language is to be of the child's rights. Then in section 2, number 2, B2, we are back to that reasonable notice. It's just consistency there. On page 5, a consultation with an attorney under this section, not merely confidential, but it also must be conducted in a manner consistent with the Maryland Rules of Professional Conduct. That's because if there is any harm of a conflict of interest, we wanted to address that. That was something that that the state's attorney's office was concerned about. So the conflict of interest issue has to be addressed as it would be addressed within the rules of professional conduct. Then we get down all the way down to the bottom of page 5. And this is when we get into the exigent circumstances at paragraph G. And that is that a law officer may conduct an otherwise lawful interrogation if the law enforcement believes about the imminent harm, a danger of the life of someone. That's on page, I'm now on page 6. And then we state that if that does happen, then they have limited, they are limited in which the questions they should be asking the child, because now there is no counsel, the parents don't know, et cetera, unless it is impractical, impossible to do so. And then we get into the body worn cameras, which I already talked about, so I won't go into that. And last but not least, there is a rebuttable presumption at paragraph H that the police officer is that a statement made by a child during a custodial interrogation is inadmissible if the police officer willfully failed to comply with the requirements of that section. And then in section I, I'm sorry, one more thing, the public defender, which I mentioned, will provide on their website and develop programs, policies, I'm sorry, to provide guidance and instruction to the attorneys to meet what is in the law, if we pass it.
All right. Delegate has been working pretty extensively on the bill. And so there are going to be questions regarding the amendments. Let's go first to Delegate Conaway.
Thank you, Mr. Chairman, and thank you, Delegate. I appreciate your work. So on the limited questions in reference to somebody else might wind up getting hurt. So if the juvenile is with a group of guys and they steal a car and they do a robbery or something, and one guy gets killed, and another guy that's in the car says that guy just killed my brother or whatever, and now the brother is going to kill this guy, then the officer could potentially ask him about them stealing the car, the shooting, and the intent, what the statements that were made in reference to the person that might be getting ready to get shot or killed.
So you brought in the car, and I'm gonna ignore the part about the stealing of the car because that would not apply. Property is not part of this exigent circumstances. It must be an imminent threat to the life. So you combined it with the threat of a life, and in that circumstance, when there is a threat of life, then it would be, unless it's just merely impossible, impractical, or unsafe to do so, then to do with all the things that are outlined, then they would have limited questioning, and they must turn on their body-worn camera if they have one. And then one more thing I forgot to mention: if they don't have a body-worn camera, then they must they can record using other video or audio recording in a manner that's consistent with the policies of their of that particular agency.
Right. So when I started out, my question was, what is limited questioning? What is that?
Okay, so
In that example,
it's actually outlined in the bill. I've just got to find that section. It is.
She's going to need you to change the page here in a second.
Yeah. It is at section. Hold on one second.
3 or 4.
Okay, so here we are on page 6 at the top. The questions posed to the child by the law enforcement are limited to those questions reasonably necessary to obtain the information necessary to protect the individual from an imminent threat to the life of the individual. So in your case, they would be able to ask questions about the threat of life, not anything dealing with the car. So it will be very limited and narrow in scope on what is necessary to protect the individual.
Right. So in other words, the officer shouldn't say, well, since, you know, once you all stole the car and then you saw so-and-so and then the shooting started taking place. And if the officer does ask about the car, which is not related to the imminent danger, then that would be inadmissible.
That's correct.
Okay. My second question, thank you on that one. My second question was, is this the same bill that we were talking about where the parent comes in and compels a child to waive their rights and where they say, go on and admit to something and then we can go, but the child doesn't have the counsel?
Yes, this is the same bill to avoid that happening.
So now
we do not want parents. The parents are not allowed to waive the rights of the child.
Right. Okay. We agree that the parents are not allowed to waive.
That's correct.
Thank you very much.
Thank you.
Delegate Moon.
I have 2 quick questions. One, can you just repeat who agreed to these amendments or who worked it out?
Okay, so Office of the Public Defender was the big help with drafting them. I posed all the amendments to the State's Attorney's Office as well as to the Office of Public Defender, ACLU, and at one point, Human Rights for Kids. I think that's if I'm getting that right. With also at one point the amendments were with the child advocacy group. So those are the groups.
And so the state's attorneys and the public defenders are on the same page on this one?
They're relatively on the same page. They're as much on the same page as they can possibly get. And I say that with all due respect, because we met repeatedly and they were, they repeated, I looked at their language, they looked at our language, we went back and forth, we met. And that is the reason why we have paragraph H, which is brand new on page 6, with the rebuttable presumption that a child
Okay, see, now you're getting at my
that
second
business,
question.
yeah, because we have
yeah.
the language. I'm sorry, Delegate Moon.
Yeah, this is actually where I'm going with this. So I just want to understand this. So the advocates who want to restrict juvenile interrogations, or at least give parents notice and all that, are comfortable with the amendments, and you have worked in amendments to address the concerns posed by the state's attorneys, and that includes what you just talked about with the rebuttable presumption. But maybe, is it possible, I guess I just want to know, have they signed off on it with this amendment? Because I was just about to ask you, that amendment says, if the officer willfully interviewed the kid, then there's a rebuttable presumption. And I guess my next question is, what happens if they claim it was an accident, or it was a bona fide accident? What happens to the admission then?
Well, that's kind of interesting, because I don't know how you would. Well, you would state that it wasn't willful. You would state that it wasn't willful, right? If it's an accident, then it's not willful, and then.
Well, I guess the kid though has no benefit then, right? Like you get the benefit of a rebuttable presumption that the statement shouldn't come in, but only if the officer on purpose took your statement. Anyway, this is why I'm curious if the essay is signed off on it with this attached to the bill, or if it's still not satisfied.
Yeah, that part was, I believe, I'm pretty certain that part was either from the state's attorney's office. If not, then it definitely was part of the discussion that they would have, and they would have seen that section when we were discussing. And they didn't have any problem with H. H wasn't their problem. That part, we didn't have any problem with that. But I think that counsel was going to say something.
Well, Delegate Moon, I just wanted to make sure you understood that it's if the law enforcement officer willfully failed to comply with the requirements of the bill. Not
I see. Yeah, no, I get that. That's why I was thinking, like, I mean, if you were totally on the side of stopping this information from coming in, it would be written differently. And that's sort of why I'm just curious on the politics of this, how far along the prosecutors came to support this bill with adding provisions like that in, I guess, is my question. Do they like it now with it in there?
And with that, I will say that they like it as much as they're going to like it. Now, literally mean
okay.
that. Yeah, I literally mean.
I won't poke too hard on that
yeah,
clause.
I literally mean that they came from here to, and then they came much closer. We're like about here now, as opposed to being like this. So yeah, we came as close as we're going to get.
Delegate Griffith.
Thank you, Mr. Chair. So with these amendments, do we know if the state's attorneys and the chiefs and sheriffs now support the bill?
Well, I don't think they're going to outright support the bill. They don't oppose the bill, okay? In the sense that they know that this is a work product in some part of their own.
I guess my question is, I'm not going to use a hold, but with this much amendments,
Well, this much, Delegate Griffith, I'll tell you, with this many amendments, these amendments went through the state's attorney's office. Some of these amendments you see, I didn't flag which ones were OPD and which ones were state's attorney, but I can tell you that it is a collaborative effort with these amendments. Now, and some of them, OPD gave some and state's attorney had to give up some. It really was a compromise, a joint effort. And then there were some things that OPD was not going to give on, and some things the state's attorney's office wasn't going to give on. But the ones, as best as we could, this is the work product that came out of that work.
No, and I really appreciate and respect the work. I know with this much, this many amendments coming out, obviously a lot of work was done on this, and I appreciate that. I would just love an opportunity to try to unpack a little bit the concerns, and that's it. Thank you.
Delegate Arakan, then Fisher.
Thank you, Mr. Chair. So tell me again, the age was at what and where is it now, Delegate Bartlett?
It's
It's a minor, so it's
a minor, under 18. Yeah.
Okay, so I've just reached out to both chiefs and sheriffs and MSA, and they are not in favor of this bill. So.
Well, you might have reached out to them, and they might have said they're not in favor of the bill, but they did not say that. They told me that there was parts of the bill that they didn't support, and so we worked on it, just exactly what I said. They did come, if you recall, in the hearing, they did come. I did not speak to every sheriff from every location, but I did speak to the association, to the representatives, and they came, and this is the work product.
Okay, thank you. Thanks for working on it. I wish we could have made the ends touch a little closer.
Well, the only way we would have been able to do that, quite frankly, is I won't go there, but we got as close as we could get.
Delegate Fisher.
Thanks, Mr. Chair. I wanted to make a motion favorable on the amendments.
Second.
Move favorable on the amendments. And a second. Is there further discussion on the amendments? Seeing none. All in favor of adopting the amendments, please raise your hands. I see Griffith, Shetty, Williams, Atterbury, Deborah Davis, Watson, Bartlett, Malone, Cardin, Moon, Fisher, Conaway, Arakan, Crutchfield, Lopez, Jones. Anyone opposed to the amendments?
Can you record me in favorable on the amendments, please?
In favor of the amendments, Grammar.
Me too, Chairman. Sorry.
And Sham, that's all right. Seeing no one opposed, the amendments are adopted. We're on the bill is adopted.
Move favorable as amended.
Second.
Bill is amended, and there's a motion for a favorable and a second. Any further discussion on the bill? Seeing none. The Vice Chair,
Yes.
Delegate Arakan,
No.
Delegate Bartlett,
Yes.
Delegate Cardin,
Yes.
Delegate Conaway,
Yes.
Delegate Cox,
No.
Delegate Crutchfield,
Yes.
Delegate Deborah Davis,
Yes.
Delegate Juanita Fisher,
Oh, yes.
Delegate Grammar,
No.
Delegate Griffith,
No.
Delegate Rachel Jones,
Yes.
Delegate Lopez,
Yes.
Delegate Malone,
No.
Delegate McComas,
No.
Delegate Moon,
Yes.
Delegate Shetty,
Yes.
Delegate Cham,
No.
Delegate Watson,
Yes.
Delegate Griffith. Delegate Williams. Delegate Williams.
I know we look so much alike. I am a yes on this, Mr. Chair.
Great. All right, 13. All right.
Thank you.
All right. Going now to House Bill 372, Delegate Moon. Delegate Moon, please tell us what your bill does. I don't believe there are amendments.
For the most part, it separates out paraphernalia used for drugs from the pretty stiff penalties associated with paraphernalia used to sell, manufacture, and distribute drugs. This was the syringe focused bill that was aimed at trying to stop people from hiding the existence of their syringes from the police, and also to stop them from ditching them on the street after use, which we believe is driven largely in part with the 4-year jail term that comes with syringes currently. So that's most of the bill, but it cleans up multiple provisions of law where these paraphernalia drug user crimes are written. But I'm happy to answer any questions about any part of it.
So in the Justice Reinvestment Act process, there are a couple different kinds of possession of paraphernalia, and this addresses in the bigger part one of them, one of the possession of paraphernalia that reasonably indicate an intent to use controlled paraphernalia to manufacture, distribute, or dispense a controlled dangerous substance. It lowers the penalty from 4 years to 1 year. And what was happening in some cases, not every jurisdiction, but in some jurisdictions, is that paraphernalia charge was used to replace another paraphernalia charge that was where the penalty was lowered. So that's part of this.
And sorry, I should clarify one thing too. Very, very important here. What we're trying to decriminalize is the syringe. The residue and the drug in the syringe is still a crime and arrestable. Okay. So what this allows us to do is to go out in the world and tell people, stop hiding your syringes from police, stop ditching them on the street. The syringe itself is not the crime. Okay. So, because I know there's going to be some confusion about this. In the current law, we also have multiple paraphernalia crimes. There's a specific marijuana paraphernalia offense. There's controlled paraphernalia, which is things that might have heightened scrutiny or for might be more for drug distribution. And then we've got normal drug paraphernalia, which is much more just drug user paraphernalia. Under current law, that sort of ordinary paraphernalia, first offense is a $500 ticket. Okay. And so for the syringe, the first offense could be up to 4 years. So there's a huge gulf in how we're treating these things. And again, that's the heart of it. But if the officer really wants to bust the person for something, they can. We're just trying to get them to stop doing it on the needle.
Can I have a motion on the bill?
Move favorable.
Move favorable and a second.
Second.
Take discussion on the bill. We'll go to Delegate Conaway.
I just wanted to be clear on something. Thank you. Oh, thank you, Mr. Thank you, Delegate Moon. So let's say if an officer finds one of those unrolled leaves or whatever, a cigar leaf, is that a $500 fine?
Like something used to roll and wrap.
Yeah. In your opinion, I mean, just in your opinion, I mean, you made the comment.
I mean, this is the problem with the paraphernalia law. Lots of things qualify as paraphernalia. And in fact, when you look at some of the specific items that are in the current law, it's like spoon, stapler, measuring cup, scale. They are objects that could be used for completely ordinary purposes, but the law tries, and case law tries to give some guidance as to what the indications are that maybe that item has a more illicit purpose. Now, I personally have a problem with a lot of this sort of, putting the offense on the paraphernalia instead of the drug dealing or whatever is the behavior is you're trying to get at. So this is one step closer to achieving that.
All right, thank you for the education. I appreciate it.
Further questions or discussion? Seeing none. We've got a motion for a favorable on the bill that was seconded. Seeing no discussion, we'll go to a roll call. Vice Chair?
Yes.
Delegate Erican?
No.
Delegate Bartlett?
Yes.
Delegate Cardin? Delegate Cardin.
I thought I said yeah.
Okay. Delegate Conaway,
Yes.
Cox,
No.
Crutchfield,
Yes.
Davis,
Yes.
Juanita Fisher,
Yes.
Robin Grammer,
Yes.
Griffith,
No.
Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
No.
McComas,
No.
Moon,
Yes.
Shetty,
Yes.
Cham,
No.
Watson,
Yes.
Williams.
Yes.
All right. 14 to 6. All right. Let's go back to the top of the list to House Bill 23, Delegate Stein. This moved out of the Civil Subcommittee, Council. They made some amendments. Holly, would you tell the committee what the amendments do, please?
Sure. So basically, the amendments add a warrant requirement, and then the part that the subcommittee worked on, if you want to scroll down, Dylan. Just a little. A little bit farther. We removed a subsection D, so we've also parsed out, it's just requiring the MVA, the department, and the Department of State Police and the Department of Public Safety and Correctional Services. Before the bill was a little bit more all-encompassing and included all local and state agencies. So we've clarified that, and then we've struck a subsection D that the department had an issue with. So the rest of it, everybody's on board and is fine with. It just kind of clarifies what is a law enforcement agency. The Department of Public Safety, scroll down, Dylan. Wanted to make sure that they were included there. And it shouldn't be crossed out. I don't know why it's processed that way, but a law enforcement agency does include all of those entities. And those are the amendments.
So for the, Mr. Chair, may I chime in?
Yes, Subcommittee Chair.
Thank you. As it came in, it asked for all agencies, and that included not state agencies, but basically all local and municipal agencies. And with advice from council, as well as with the work, a lot of work from the sponsor and from the subcommittee, we limited it down to the three agencies that are the most important, which are Department of Corrections, State Police, and the Motor Vehicles Administration. Those are the only three agencies that are impacted. We checked with all three agencies, and all three agencies are not opposed to the bill now, the way that it's drafted. Furthermore, we got rid of that subsection D, which was not included in the Senate legislation, and we're not exactly sure how and why it got in. It's at the very, very bottom of the page. And that gave a lot of, that made the Department of Corrections much happier that we got rid of it for whatever reason, even though I'm not exactly sure why they cared, but everybody was of it. And finally, the definition of an agency is specific to this legislation because it only defines the agency as the three that we talked about, so that no other agencies would be included in the legislation.
Delegate Cardin, do you want to mention the AG letter just for clarity?
There was a question as to whether this was constitutional to do. There was an AG letter from 2018, but it only referred to MVA, even though there was no reason why it couldn't have been expanded to other agencies. So per the request of Department of Corrections to make sure that they were okay, we asked for an updated letter for 2021, which included them and any other agencies that may be included. And the AG letter does give us the authority to be able to do it.
Move the amendments.
There's a motion for the amendments. Is there a second? Motion is second. We'll get to discussion now on the amendments. Let's go with Delegate Juanita Fisher, please.
I'll lower my hand. I was raising it to make a motion.
And we appreciate it. So let's go to Delegate Arakan instead.
Thank you, Mr. Chair. So Delegate Cardin, I just want to double, triple check. So this does not include like my sheriff's office now.
No, it does not include your sheriff's office. It only includes Department of Correction, Motor Vehicle Administration, and State Police.
Okay, and they can still get a warrant. This is just they can't have open access. Is that what it is?
Right. So in order, and Holly, you're gonna have to correct me if I'm wrong, but in order for them to be able to get the information, now they're going to be required to get a warrant in order for them to access the information.
Okay. Did any of the opposing people switch their unfavorables after that, after the changes? Besides just I know the info changed, but any unfavorables contact you?
For example, the Port Authority came in opposed to the bill, but they're not opposed anymore because they're no longer included in the bill.
Gotcha.
So the ones that are included, DPS, Department of Public of Corrections, it's not DPS. Department of Corrections was opposed. We got rid of subsection D below, and we also made sure they had the updated AG letter. And correct me if I'm wrong, Holly, but they told us, both of us, they are no longer opposed to the legislation.
Okay, thank you. Thank you very much, guys.
All right. Is there any further discussion on House Bill 23? We had the motion for an amendment and a second. All in favor of the amendment, please raise your hands. Delegates Fisher, Conaway, Watson, Bartlett, Shetty, Davis, the Vice Chair, Williams, Malone, Crutchfield, Moon, Cox, Cardin, Lopez, Jones. Anyone opposed to the, and Arakan, and Sham. Anyone opposed to the, and Griffith. Anyone opposed to the amendments? Seeing none. Thank you very much. The amendments are adopted. We're now on the bill as amended. Is there a motion?
Move favorable as amended.
For a favorable and a second on the motion to move the bill favorable with amendments. Any further discussion? Go through a roll call. The Vice Chair,
Yes.
Arakan,
No.
Bartlett,
Yes.
Cardin,
Yes.
Conaway,
Yes.
Cox,
No.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanita Fisher,
Yes.
Grammar,
No.
No.
Jones,
Yes.
Lopez,
Yes.
Malone,
No.
McComas,
No.
Moon,
Yes.
Shetty,
Yes.
Sham,
No.
Watson,
Yes.
Williams.
Yes.
13-7. Right. Oh, Delegate Shetty. Delegate Shetty, House Bill 240. There is an amendment that is being pressed, but there's also the sponsor's amendment. So what I'd like to do is do the sponsor's amendment first, and then I understand that Delegate Grammar has an amendment that he's properly submitted to the committee. I haven't seen any other amendments that were submitted to the committee, but Delegate Grammar did submit to the committee and submitted to committee staff. Delegate Shetty, if you would talk about the amendments that you have worked out on the bill.
Thank you, Mr. Chair. Thank you, committee colleagues. It is very late, so I will just share that as a reminder, this is a bill that establishes a regulatory framework here in Maryland for the use of forensic genetic genealogical searches by law enforcement. It is a very, very carefully negotiated, balanced bill. Once you incorporate the sponsor amendment in particular, that represents 3 years of work plus the last 6 months of pretty intense, careful negotiation between all sides of the spectrum, from ACLU, Innocence Project, OPD, many academics who specialize in this, MSAA, MSP, and the chiefs and sheriffs. And I hope I didn't. I will add that I forget the name of the coalition, but the coalition that's comprised of Ancestry.com and 23andMe had some initial concerns that they had expressed both in subcommittee and full committee about unintentionally being captured by this bill. We addressed them through some technical amendments that were adopted in the sponsor amendment as well. So they too now support this bill. The amendments are pretty detailed. I'm happy to answer specific questions that colleagues might have, but essentially, as I mentioned, this just establishes a regulatory framework. It puts significant guardrails around the use of this technology, specifying a limited number of crimes in which it may be utilized, requires a court approval at the outset of the utilization of this. And it also requires post all appellate rights being exhausted, all the data must be destroyed. So we believe, and I believe very strongly, that this is a really strong bill. It is a first in the nation effort. And I'm really happy to answer any questions that you might have.
Move the amendments.
Motion for the amendments. Is there a second?
Second.
All right, the amendments are moved and seconded. Discussion on the amendments. Is there anybody who has any questions they'd like to ask Delegate Chetty, our resident expert now in genealogy.com? Any questions? Delegate Conaway.
Thank you, Mr. Chairman. Thank you, Delegate, for bringing the bill. So the way this works is the law enforcement could get a warrant for your family members' DNA, or they run a DNA sample, and they'll get a hit on your family member. Is that correct?
So close. So the first thing that is required by this bill is that essentially at a crime scene, a sample of DNA is obtained, which is then run through all reasonable investigative leads. And then once those reasonable leads have been exhausted, then law enforcement and investigators, if the crime falls under the very narrow set that is established by this bill. So we're talking like the most heinous acts: murder, rape, felony sexual assault. And I think we also included like if there's an ongoing threat to public safety or national security. So like think somebody's about to detonate a bomb, something really.
Sure.
Then what they'll do is they'll go to the court and indicate that they'd like to do one of these searches. They can only utilize databases where the consumers within the database have been provided notice and consent that law enforcement may utilize it for law enforcement purposes. Then they can run a search to see if there's.
Can I stop you right there?
Yep.
Is that a normal part of requesting this ancestry to be run on a person? In other words, if I want to find out if I'm from Ireland and I go to one of these ancestry places, are they going to say, well, just so you know, you're consenting to in the future, your DNA might be part of a database that'll be checked by law enforcement?
So that is a very good question, Delegate. Thank you for asking. There are some databases like Ancestry.com and 23andMe that do not consent to law enforcement utilization of their databases. So they would not be this bill would not apply to them because they don't have that currently. There are other databases that are like more open source, and typically the way that that those operate currently, and many of them already do, provide notice to their consumers and active consent, which can then also be withdrawn at any point. So
notice to the consumer, does that mean when you sign up to have this done? So you'll sign an approval to say, go ahead and run that when you sign up in the beginning. Is that right?
That's correct. Yes. Or if in the event that like the database decides to open up to law enforcement, they would have to notify all of their users and provide an opt-out to those who do not consent. So like if say tomorrow ancestry.com, and I don't believe after conversations with them that this is the case, so this is a total hypothetical, but if say tomorrow Ancestry decided that they wanted to open up for law enforcement search, they would have to then subsequently provide notice to all of their consumers and the public, and then they would have to get consent from users who wish to opt into that type of database.
You said opt in, but before you were saying opt out.
Right. What I was saying is that if you later decide you don't want to allow, you can opt out.
So if they originally don't participate in that, then you would have to opt into it.
Correct.
Okay. Thank you very much.
You're welcome, sir. Thank you.
Delegate Griffith.
Thank you, Mr. Chair. And inside every Republican is a libertarian dying to get out. So I'll be playing the role of Robin
Some
Grammar.
of us Democrats too, a little bit.
That's where we meet in the middle.
Yeah.
I want to follow up on some of Delegate Conaway's comments. You know, a lot of these services, when people sign up for them, they're fact finding and, you know, trying to find out for themselves about their own information. And they're certainly not anticipating, only way I can say is Big Brother, you know, snooping around their DNA and things of that nature, and they're in their ancestry.com. And so do we have any language in the bill or the bill as amended that kind of gives guidelines to how these notices are done? And the reason I say that is because anybody's ever signed up for, you know, the I accept the terms of use on your iPhone, it's
yeah, no, this
1,000
is a
pages,
really right.
and somewhere on page 4001 in little tiny print, oh, by the way.
No. Yeah, no, I hear you. And this was actually a very lengthy topic of discussion in our work group as well. Many of the stakeholders had that same concern that this would just be buried within like a terms of use document that, you know, nobody would read. But no, this is like an explicit notice and consent. So it would be.
So this is a relatively short standalone notice of consent.
I mean, we didn't specify like the exact words they have to use.
Sure.
A separate notice and consent. So they would have to offer the ability to the consumer to do that. And I think that some advocates have expressed an interest to continue to revise that particular component of regulation on these databases next session. So this bill really is primarily a vehicle for the law enforcement utilization of these and regulating those, you know, privacy concerns that you and I both share. But I think that there is a separate interest to have a further, deeper conversation about, you know, how do we regulate, you know, the use of these databases overall and protect consumers. And that's like more of an ECM thing, less of a Judiciary Committee thing.
Sure, that's my big kind of like cloud over this, you know, Bill's trying to do. I appreciate where we're going with this, yada, yada. But that cloud of how somebody, you know, because like I said, I use the
I
app.
hear you. Yeah, and me as well. I mean, and this is the consumer must be provided the opportunities. They would have to be notified, and the public has to be notified as well. And then consumers have to consent to this.
Right.
Most of the databases that do that are open source databases where the users are actually uploading their own data after they're getting it from somewhere else. So, and it's again, primarily really being used for, like they're primarily doing it so that they can, you know, further the likelihood that they find a relative, right? They're not doing it to aid a law enforcement investigation necessarily.
And sorry, Mr. Chair, I know it's like one final point of clarification. So retroactively, if say 23andMe rolls this out, everyone retroactively would have to opt in.
That's correct. So once a database decides to open itself up to law enforcement utilization, then they would have to provide notice to consumers as well as to the public and consent to those users. They would have to opt in.
Thank you.
You're welcome. Thank you for the
Thank
question.
you. Delegate Juanita Fisher, please.
Move favorable.
Okay.
Second.
All right, we're on the amendment, so we're on.
Move favorable of the amendments.
All right, that's
The
fine.
amendment.
There's a favorable and a second on the amendments. All in favor of Delegate Shetty's amendments, please raise your hands. I see delegates Fisher, Griffith, Conaway, Arakan, Bartlett, Watson, Shetty, McComas, Cham, Deborah Davis, Atterbury, Williams, Malone, Grammer, Crutchfield, Moon, Cox, Carden, Lopez, and Jones. I don't see anybody who didn't raise their hand. Those amendments are adopted. Now, we have amendment from Delegate Grammar, and it's 443020. Delegate Grammar, please, with your, with your amendment.
Thank you, Mr. Chair. I appreciate it. And let me start by saying, I think Delegate Shetty's done a fantastic job of communicating with me about the bill. I won't say that much of other particularly lobbyists who have worked on this. I've been a bit frustrated. I've received a couple nasty emails personally about this, which frankly has left me furious. But I think that this amendment covers a hole that's very much in the spirit of the bill. And I think this process does deserve guardrails around it. But the intent of the bill is to get at the cold cases. And most frequently, these kidnapping and human trafficking cases are the coldest of cases. And I think in these particular examples, making this small change really provides access to a potential lead for these cases, frankly, sometimes go years or decades without a solution. I would ask everybody to keep in mind that what this bill does is it not only puts guardrails around when this can be used, but it will also limit it to, now the process is completely open. We would be the first state to say, hey, we're going to limit this to particular crimes. And I think, talking with Delegate Shetty, as the conversation with the stakeholders happened, they came to an agreement, but on the particular crimes that this would cover. But frankly, I don't think that makes much sense. If you look at page 4, line 10 of the bill, I mean, you cover murder, felony sexual assault, okay. And then you have this big giant hole, acts present a substantial and ongoing threat to public safety or national security. Well, technically that could be anything. So just thinking about when you would actually practically use something like this to get a lead on a cold case. The kidnapping and human trafficking, I think it applies to most. And I'd ask everybody to consider the fact that you actually need one of these DNA profiles to even request access to this under this bill. There are certainly cases where if you had a kidnapping, you would have no DNA and this wouldn't apply. And I think that's as it should be. But I think in the case of kidnapping, someone's kid, most Marylanders would want us to do this so we could try everything possible to get a lead in those cases. So I'd move the amendment, ask for a second. I'd ask for your support.
The motion, there was a motion to move the amendment. Is there a second?
Second.
A second. Okay. We have questions now. Delegate Conaway.
Thank you, Mr. Chairman. To the maker of the amendment, can you tell me what is human trafficking?
I'm sorry, I don't have the definition in front of me.
Is human trafficking the same as if you pay somebody to bring you into the country?
Please.
No, if I can, I'd like to defer to counsel because I want to get the definition of this straight.
I'll wait.
I'm looking it up.
One moment, please. (31101), Claire.
311, okay, thank you. Yeah,
31101, yeah.
they moved it, we moved it recently.
Can I ask a question while we're waiting?
Sure, go ahead.
Okay.
Thanks, Mr. Chair. Would the maker of the amendment consider separating out sex and human trafficking so it makes it more explicit what we're talking about?
What do you mean?
So instead of just saying the title sort of human trafficking, could we do sort of human trafficking sub letter A, sex trafficking sub letter B, labor trafficking, so that
So what
we're
the
capturing
amendment
all-
does is actually adds this into a section that includes the other crimes. So
Right.
without getting into the weeds or really trying to rearrange the sponsor's bill.
Yeah.
I appreciate your point, but I think it does what we're looking for it to do.
Okay.
We'll get the definition of human trafficking here in a moment. Let's go ahead with Delegate Moon's question.
All right, so does this delete the catch-all provision? It
No.
says it doesn't.
Does
So
not.
you're adding to the bill additional crimes. So I guess I have to pivot to the sponsor of the bill then and ask, I mean, this is the only problem I have with this, is it sounds to me, stop me if I'm wrong, sponsor, that we already had people sort of look specifically at which crimes to enumerate in the bill. And so I guess my question is, will we be disturbing some balance that was reached between the prosecutors and the defenders with the current language in the bill by taking this language?
If I may answer, Mr. Chair.
Delegate Shetty.
Thank you. Thank you, Delegate Moon. In short, yes. Thank you for the question. This was a very carefully constructed balance. And furthermore, I shared with the committee, and I apologize. I know that this is, not usual to do such a thing, but this morning I wanted, again, because of the complexity of this bill, I wanted to provide some additional food for thought. So I sent an email in response to Delegate Grammar's very well-intentioned amendment with input specifically from some of the stakeholders, including the Innocence Project. Their new policy council came from the Maryland Human Trafficking Coalition. He was their policy council before coming to the Innocence Project. And so he's, I think all of us around the table in this committee are super incredibly sensitive to the fact that kidnapping and human trafficking are also very heinous crimes.
I can't say that because I haven't heard the definition.
Sure. Okay. Well, I don't want to speak for.
We'll get that in a moment. Go ahead, finish up Delegate Shetty, and we'll get in here in a second.
Thank you, Delegate, for correcting me. So I would say that I believe many of us believe that these are heinous crimes. However, not only will adding it upset the balance, but I think that it could also potentially set up this new regulatory framework. Unintentionally set it up for, potentially not succeeding, because we limit it to these types of crimes where it could effectively be utilized. You need to be able to first have a DNA sample from the crime scene, and that's not likely to be the case in these types of crimes. And so I totally respect Delegate Grammar. He is a very good friend, and I'm so grateful for this very well-intentioned amendment. But I would please ask my colleagues to vote no on it, which is very good of you again, friend. I apologize.
Absolutely. And if I could respond, Mr. Chair.
Delegate Grammar, please.
And that's my rub. I was sympathetic to the issue when Delegate or Senator Sidnor brought it initially. I'm sympathetic to it now. I'm with you 99%, but I do not work for lobbyists. I love the state's attorneys and the Office of Public Defender. I do not work for them. I don't think this committee is a proxy ground for them to work out their political differences. I think we should do what the right thing is here. And I think Delegate Cardin's right when he always says somebody submits a bill to the committee, we should try and do what we think is best here. This is going to be state law. It's going to impact every district. And in the spirit of this bill, these are the coldest of cases. These are what you see on the side of a milk carton. This is what you see on circulars every day. Lost children, lost family members. So I appreciate you. We've talked. You've been great in communicating with me. I hesitated to even do this, but I really feel strongly about it. And I hope everyone can support this.
All right. Is there further discussion? We're human trafficking section, for what it's worth, is 311 in the section 11 of the.
It's very lengthy. It's, we don't have enough time to read the whole thing, but it's basically taking or causing another person to be taken to a place for prostitution, or persuading somebody to engage in prostitution, or receiving consideration for somebody else engaging in prostitution. Or it could also involve taking somebody's passport or immigration documents and forcing them to engage in prostitution. And if the victim is an adult, it's a misdemeanor. And if the victim is a minor, it's a felony. And then another statute that's marriage trafficking, which is similar, but basically forcing somebody to marry another person, and that's a felony. And then there's another whole subtitle on labor trafficking.
All right, Delegate Conaway, that address your question?
No, what I'm trying to get to is if I pay someone to smuggle me into the United States of Mexico, is that person who's smuggling me in on, say, a tractor trailer or a train or something like that, are they a human trafficker?
Well, it has to involve, under the one statute, it has to involve prostitution. And I don't think that's a part of.
Oh, it has to involve prostitution.
Yes.
Okay. All right. Thank you. If you're 100% sure about that, then you've answered my question.
All right, thank you. We'll go, Delegate Moon, your hand is still up. Did you mean it to stay up or no? Delegate Erican, then Cardin.
Thank you, Mr. Chair. Could council just tell me, under the portion of the bill that says, public safety or sort of like imminent, could you read that language? Would a missing child, because there's obviously an imminent threat to that child's life, would that already be encompassed in that part of the language? I mean, what could be a more imminent threat than a missing child? You know what I mean? I'm not even sure. I want to see if that's already, if your opinion is that that could be covered under that piece.
Well, under the, with the amendments, with Delegate Shetty's group's amendments, the language would be that the crime is the commission of or the attempt to commit murder, rape, a felony sexual offense, or a criminal act involving circumstances presenting a substantial and ongoing threat to public safety or national security. So if there's a missing child, that would be a matter of interpretation for the court.
Okay, so there's a chance it could be considered depending on the judge you get, maybe.
Right. I mean, if there was a suspicion that the child was being, molested or something, then that would fit into a felony sexual offense.
Right. Okay.
Or it could say that it's a threat to public safety.
Right. If there's like more than one child taken in a certain area in a certain amount of time, maybe a judge would see. But it wouldn't really touch the really cold cases, I guess. But okay,
right.
Thank you very much.
Delegate Cardin, then
Mr.
we're
Chair.
calling the question.
Thank you, Mr. Chair. Just very brief. I just think that perhaps if this is working with what has already, with the narrow, different enumerated crimes that we put in it, and if it's working, perhaps we come back, or the state's attorneys can come back and try and expand it. But I think that given the fragile alliance we've created, I think as much as I like the idea of what Delegate Grammar is doing, and I would love to come back with the state's attorneys and Delegate Grammar and support his amendment as a separate bill.
All right, thank you very much. We'll call the question, and let's just we'll do a roll call on this one because we'll see where we are. Here we go. On
the amendment?
on the amendment. We are on the amendment. There was a motion and a second on Delegate Grammar's amendment. All right. The vice chair,
Yes.
Delegate Erican,
Yes.
Delegate Bartlett,
No.
Delegate Cardin,
I am really struggling. Really, I just don't know if this is going to ruin our alliance, our what we've set up, and all the people together.
Take a leap.
No.
Do the right
no
thing.
lobbying, please. Just voting, please. Delegate Cardin, need your vote.
Yes.
Delegate Conaway,
Yes.
Delegate Cox,
Yes.
Crutchfield,
No.
Deborah Davis,
No.
Juanika Fisher.
No, but can I explain my vote very quickly,
Yes.
Mr. Chair? I
You can
wanted to
explain your vote.
respect Delegate Grammar and his good intentions. And I mean, Delegate Grammar and I don't always agree on everything, but when we do, it's always great. And I find his perspective and his care most admirable. So I really support him in the issue, but I also respect the work, the time, and the effort of my good friend from Montgomery County and all that she's done to make this bill where it is. So I'd have to be no for now. Thank you.
Delegate Grammar, oops. Mute button is against me. Delegate Grammar,
Yes.
Delegate Griffith,
Yes.
Delegate Jones,
No, sorry.
Delegate Lopez,
No.
Delegate Malone,
Yes.
Delegate McComas,
Yes.
No.
Delegate Moon was a no. Delegate Shetty,
No.
Delegate Cham,
Yes.
Delegate Watson,
Yes.
Delegate Williams.
No.
You don't need 12 on an amendment. The motion passes 11-9. The bill is now as amended. Is there a motion on the bill as amended?
Move favorable.
Motion for a favorable. Is there a second?
Second.
And a second. Is there further discussion on the bill as amended? Seeing none, the vice chair.
Yes.
Quick question.
Okay, Delegate Malone for,
Do we know, and I apologize, the sponsor delegate may have said, are the state's attorneys now supportive?
They do support with the amendment, the sponsor amendments. I don't know the status of any of the groups with the new amendment added.
All right, thank you.
the vice chair.
Yes.
Delegate Erican.
Yes.
Delegate Bartlett.
Yes.
Delegate Cardin.
Yes.
Delegate Conaway.
Yes.
Delegate Cox.
Yes.
Delegate Crutchfield.
Yes.
Delegate Davis.
Yes.
Delegate Juanika Fisher.
Yes.
Delegate Grammar.
Yes.
Delegate Griffith.
Yes.
Delegate Rachel Jones.
Yes.
Delegate Lopez.
Yes.
Delegate Malone.
Yes.
Delegate McComas.
Yes.
Delegate Moon.
Yes.
Delegate Shetty.
Yes.
Delegate Cham.
Yes.
Delegate Watson.
Yes.
Delegate Williams.
Yes.
It's 20. Okay. Where are we? we're gonna do. All right, committee, it's 10:48. We're gonna stop right here. We're gonna come back tomorrow at 10 in the morning. We're gonna come back tomorrow at 10 and we are going to continue with the list. I don't believe that we're going to see the Baltimore City Local Control Bill tomorrow, but the committee will be addressing that issue. I don't want people to be concerned about that. But there are a number of other bills, and I think at this point, as we get closer to 11 o'clock, I'm going to stop us here. That concludes the voting session for tonight for the House Judiciary Committee. We will be back tomorrow at 10 a.m. 10 a.m. tomorrow on the 19th.